Welcome to video number 2 for the law offices of Brent Williams-Ruth. I am Brent Williams-Ruth, and I'm here from my messy home office, my second broadcast location, to bring you the first substantive video pertaining to estate planning, estate preparation for residents of the state of Washington. First, a legal disclaimer. This is provided as a general educational overview. It is not meant to give any one specific legal advice, and that you should always make decisions specifically with a legal advisor. Okay, that said, what is estate planning? Estate planning in Washington generally consists of the creation of a testamentary document, generally called a last will and testament. A personal property memorandum. That means if you want to give away this lovely cup, insulated cup, to somebody because they've always wanted it, you can put that on a personal property memorandum. Your general, durable, financial power of attorney. That gives somebody the authority to act on your behalf while you're alive, but you need someone to do some tasks for you. This could be a happy situation. You're at a friend's wedding in another country and you forgot to pay your cable bill. Your power of attorney can do that for you. Or you've had a massive stroke and you're laying in a hospital and you can't even talk to anybody. Somebody needs to pay your bill. Your power of attorney. All right. Then you have the durable medical power of attorney. So this is kind of hard to think of a situation other than the reality of you are in a medical condition where the doctors cannot talk to you in that you're not responding, or you've lost capacity and the medical providers do not believe that you are able to take care of yourself and make decisions for your own best interest. Medical power of attorney. Then there is what's called the Healthcare Advance Directive. This is the pull the plug document. You're in a terminal, permanent, unconscious condition in a hospital, and the doctor comes to the primary power of attorney and says, "We're really sorry. They're never coming back." This is your instruction to the people as to what do you want to have happen. Okay, that's the base executable documents, meaning documents that actually need to be signed. Some need to be witnessed, some need to be notarized, some need to be signed, witnessed, and notarized. But that's not the end. There's also ancillary information that goes along with estate planning that makes things easy for the people you leave behind. Number one, I've created a document that I call the treasure map. Okay, fine. Officially, it says the summary of assets and liabilities. This tells people who owes you money, who you owe money, and where to find your money. So when you're gone, they can take care of what needs to be taken care of. Then there's a document called the Final Instructions of the Family. This deals with body disposition. Do you want to be cremated, composted, Norwegian Viking burial out in a fjord in Norway where a marksman is standing on top of a fjord and is going to shoot a flaming arrow into a rowboat, thousands of feet down below, and you're going to burst into flames down that way. Who knows? Do you want to be buried at sea? Do you want to be buried from a Washington State ferry? And by the way, no, they will not just dump your body. It has to be the cremated cremains or ashes. But then it goes into, how do you want to be remembered? Do you want to have a giant celebration of life? Do you want to have a solemn funeral? These are all the things that go into the Final Instructions of the Family. Okay, that's the base document. See how easy? It took me less than 4 minutes to explain that whole thing. The process of creating them with my office is not terrible. In fact, the number one compliment I get from my clients is, "Wow, that was a lot easier than I was expecting it to be." You don't have to have this process be the same or similar to a root canal. I'm just saying. The thumbnail I'm using for this picture, it's the Grim Reaper, because sadly, I'm around death and dying and the discussion of death and dying every day, so I have a little morbid sense of humor. And again, maybe that's good for you. Maybe you want someone who's going to have the button-up tie and be very solemn and serious. I can do that too. There's just an extra fee for it. Kidding. All right. Now I want to talk about the number one thing that people call me about every week, and that is, I want to trust. No, you don't. There you go. I said it. It's just as simple as that. Trust me on that. Okay, I'll explain more. National figureheads, national companies, including financial advisors, are getting advice from a legal department that is speaking toward the largest states in the country: California, Massachusetts, New York, Florida, Illinois, just to name a couple, where having a revocable living trust is the preferred and recommended estate planning technique. And they have individual specific laws in those states that make an RLT the way to go. Now, I just came from the Washington State Bar Association Real Property Probate and Trust annual mid-year conference in Walla Walla, Washington. And the number of speakers from a variety of the largest, most powerful and expensive law firms in Washington were making jokes about how people call them and want to trust. I get that Susie Orman speaks to you, but she's not talking about you as a Washingtonian. There is no tax benefit. You are not avoiding the Washington estate tax with a revocable living trust. There is no creditor protection. You still have to go through the debts that you legally owe are there. Now, are there trust options that can provide you with certain protections from the estate tax? Yes, there are. Is it easy? Does it allow you to maintain complete and total control of all your assets? No, it does not. Which is why even my high net worth clients, the vast majority have not elected to set up a trust that will avoid the estate tax in Washington, because that's just not what they want to do. People don't want to give up control of what they've worked so hard to attain. So this is a very quick, very short video, but trust me when I tell you that in Washington State, you are well served by a last will and testament that may include what are called testamentary trusts for like minor children, or maybe you have a special needs child or adult that you're taking care of, that you would create a special needs or supplemental needs trust. Different than a revocable living trust. Again, all the more reasons why you should be working with a legal professional. All right, I'm promising to keep these short, quick, and to the point. If you or anyone you know could benefit from talking with my office regarding estate planning or estate administration, I invite you to give a call by calling the office at 253-285-7751. Please know that at this time, consultations are still free of charge. I am not joining the ship of people who charge for consultations. That may change in the future, but as of today, June 7th, 2023, free consultations. Take care. Have a wonderful day.